Here is part 3 of lecture 12 about what is intellectual property, and you see how intellectual property is changing as we have different medium of disseminating information. And this one is very interesting because it's at what point an intangible electronic copy of a work has been made. And please remember about at the beginning when I said about compilation of fact, it's copyrightable because of the originality of putting this information together. And it's just keep that in mind. So copyrights in a digital information, and you're going to see how the law is trying to not change as much, but update the law because of the different change of that's going on in as to relate with people. Because of the internet, and because of the internet, it's telephone. Much of the content on the internet consists of copyrighted intellectual property. Almost everything on the internet, it's information of somebody and the nature, and also it's freedom of information. I mean, we want to communicate, we want to express ideas, we want to share information. When Congress drafted the principal United States law governing copyrights, the Copyright Act of 1976, cyberspace did not exist for most of us. At that time, the rights of copyright owners were threatened not by computer technology, but by unauthorized, tangible copies of works and the sale of a right to movies, television, and other media. You know, you had copies of papers, of documents, hard copy we call it today. For example, to sell a copy of a work, permission of the copyright holder is necessary. However, at what point an intangible electronic copy of a work is being made? You know, is it when you print out the material? Well, before we go into that, I want to explain the 6 characteristics that are very distinctive in our digital medium that cause disruptions and adjustment with existing intellectual properties laws. The first one is ease of replications. And of course, what happens? We can easier copy. It doesn't cost anything. And it can be sold at a price. And how can you find out where it comes from? Therefore, any property that is involved high development cost and low production is vulnerable to piracy. Much, much easier because it really doesn't cost us anything to copy information on the net. The second one is easy of transmission and multiple use, and which opens it to more widespread abuse because more people, this is global, they can have it. Plasticity of digital medium. What is that supposed to mean? It's easy to amend. We can change it, we can change the format, we can change the page number, you name it, in a few moments. Equivalence of works when in digital form are much difficult to distinguish. In digital form, same medium, blurring between data and writing and machine, and data and machine. We just don't know the difference. Compactness of work in digital form. Here's another difference. Do not take much space. Easier to steal. IBM store a gigabyte of data in 1-inch square magnetic disk. I mean, compilation material is put together in a new way, capable versus the print world, so different way. And there's even more. Non-linearity, non-linear experience for developing new methods of searching them and linking them together. For example, in the printing search through text tend to be quite linear table of content indexes and biography. We underline parts to find, again, we turn down pages corner and we insert the book. You know, this is what we do when we we want to copy something from the book. Well, in the internet, we don't have to do any of these things. And of course, is downloading a picture to RAM a copy? First question that's going to come in this lecture. Because of the nature of cyberspace, court in May System Corporation versus P Computer Inc. in 1993 have held that loading a file or program into a computer's random access memory or RAM constitute the making of a copy for purpose of copyright law. Downloading, even if it's for a little while, RAM is a portion of a computer, which I'm pretty sure most of you know, into which a file, for example, is loaded so that it can be accessed, read, or even written over. You're violating copyright laws. Thus, a copyright is infringed when a party downloads software into RAM without owning the software or otherwise having a right to download it. Other rights including those relating to the revision of collective works, such as magazines, were acknowledged 30 years ago, but were considered to have only limited economic value. How does the old law apply to these rights? Because now all at once we have databases, we have RAM, we have computers. So here is a case in your textbook which went all the way to the Supreme Court of the United States in 2001. And I remember when this case was heard in the district court, in the appellate court, and the Supreme Court. And it was one of those things where, yes, who owns it? New York Times. No, reverse does not own New York Times, but the Senate. Then it went all the way to the Supreme Court. When the New York Times signed a contract that allow computer database companies, now here you have a third party, including LexisNexis, to include editions of their publication in their databases, the publishing companies believed that they had the right to do so, because they already worked with the publishers, they already, with the author, they already were rewarded for the work. Now remember, what is the primary objective of copyright law? It's not to what? It's not to reward the author, but is to promote science, the progress of science and art. So remember that. So here is a situation that they have the stuff in the database already. But 6 freelance authors whose articles had been published in these periodicals in the early 1990s disagreed. So here is New York Times selecting some of these short stories or articles, if you want to call it, and making it a new edition, if you want to call it. So 6 of them did not agree. They felt that they should be rewarded again. The case was argued all the way to the Supreme Court of the United States. Please read the case in your textbook and discuss the following questions. How did the court decide it? Which is the Supreme Court that wanted to hear. And again, there's a big fight between freedom of speech, ownership. New York Times believed that they already owned it because the authors were already rewarded. They did not take all the articles of the database. New York Times selected the articles, which one they will use, which one they will not use. So they felt their expression was original. So please read that, because you'll see how the court sees this perspective now. And now here comes the computer database. Consider the various stakeholders affected by the ruling. Who is helped by it and who's hurt by it? How about the libraries? How about the academia world? Please answer these things. Here we go to another statutory protections that I thought that was very interesting, just for you know. No Electronic Theft Act, 1997. Digital Millennium Copyright Act, 1998. This is very important, the MCA Act, which provides civil and criminal penalties. So you're committing a crime because the statute says you're committing a crime to circumvent encryption software like DVD. Keep this in mind. Limits internet service provider liability for subscribers act. And then, of course, the fair use exception for libraries, university, and others is limited. For example, circumvention is allowed to test computer security, to conduct encryption research, to protect personal privacy, and to enable parents to monitor their children's use of the internet. Because remember, all these things really is putting censorship on your freedom of speech, invasion of privacy, you name it. A lot of these rights are violated because of circumvention. The exceptions are to be reconsidered every 3 years because of this. These exceptions, every 3 years, they have to go back and be reconsidered. Copyright laws versus freedom of speech. Big conflict, big tension. A major contemporary legal debate today concerns free speech right in the context of intellectual property in digital form that is encrypted. I mean, that's what we're doing it, to prevent its unauthorized copying and use. So big argument about regarding encryption, because according to the court encryption is speech. And therefore, Congress or government or agency of the government cannot really get into. And of course, their reasoning is what? The safety of the nation, especially after 9/11. Very, very interesting. The courts are addressing more than ever the tension between movie studios, which are encrypting their DVDs, and hackers who have posted code cracking programs on the internet so the DVDs can be copied numerous times. The freedom. I mean, the freedom of downloading a movie, the freedom to download the music. How many times I heard even my own sons, you know, I'm downloading music to make a CD for my birthday as a present, you know. I mean, that's the beauty about the internet, but it's illegal. It's illegal. As soon as encryption technology was used to safeguard the content of DVDs, the code was cracked by a group of hackers, including 19 years old Norwegian John Johansen. 19 years old, and he was not even from this country, he was from Norway. His decryption program, called DECCS, was quickly made available at various sites on the internet, including 2600.com, owned by Ed Curley. So here's this 19 years old, freedom of speech. DCC violated the Digital Millennium Copyright Act, since it prohibits the circumvention by decryption programs of encryption systems that are embedded in intellectual property to protect the property from piracy or unauthorized use. And this is tension because encryption is freedom of speech. So here you have a case in your textbook, Universal Studio versus Eric Curley in 2001. Read the case in your textbook and discuss the following questions, please. Again, the debate is between protecting the right of the individual, including, if you want to call it 19 years old, freedom of speech, freedom of expression of an idea. I mean, he's expressing an idea in a different way. What was the defendant's legal claim, and why did he lose this case? Do you agree with Curley? You know, and again, this case was argued in a higher court. Here we have a different approach that I wanted to share with you. In November 2001, and what I mean by different approach, you see the judge rules in favor from a different perspective. A California appellate court reviewed a case brought by a trade association of movies industry businesses against internet website operators who made DECCS programs available from their website. The trade association asked the court to enjoin the defendant from copying, distributing, publishing, or otherwise marketing the DECC programs because by doing so, the defendants were what? By necessity disclosing or using the trade secret contained in the encryption programs. That's something that they business interest. The California appellate court weighed on the side of free speech and refused to grant the injunction. In contrast to the Universal Studio decision that you have in your textbook, the court reasoned that the DECCS program was a form of pure speech. And I'd like you to distinguish the cases because in this situation, DECC is what? Pure freedom of speech. Furthermore, stated the court, the scope of protection of trade secret does not override the protection offered by the First Amendment. Now, here is something that it's trade secrets involved. It's business interest. The Universal City, what is it? What kind of type of intellectual property was involved? And remember, trade secret protects what? It's also the expression of the idea and the idea. So it's very, very interesting. The California legislature, Congress, is free to enact laws to protect trade secrets, but these provisions must bow to the protection offered by the First Amendment. The First Amendment, the rights under the Constitution, still, here we go, the balance again. They weighed it between the right of the individual and the rights of society at large. In that situation would be the industry, and which one has more power or more weight. The court labeled any attempt at blocking the future use of computer programs an impermissible prior restraint on website operators' First Amendment rights. So this is where the court ruled in favor of the website and not the industry. A 19-year-old New Jersey college dropout named Sean Fanning, who in January 1999 released computer code that allowed him and his friends to share their collection of digitalized music MP3 files. Again, 19 years old. I passed that age, so I guess that's why I cannot do any other stuff. A few months later, Fanning dropped out of college and acquired venture capital and founded Napster, Inc. And of course, all of you know about the Napster case, and I will post the entire case because it will give you a very good debate of the judges, why Napster was contributory negligent. Apparently, there were like 5 million clicks of people downloading music, and they couldn't take each individual to court for negligence. So Napster was liable under contributory negligence because they contributed to the negligence of the 5 million clicks. Well, anyhow, what is at stake in a Napster and MP3? What would you say about the ethics of Napster, of DECSS? Again, the ethics, the balance between your right of freedom of speech and the ethics, consequences. Remember, we have the same thing in cyberspace, outcome-oriented, what's going on here. And of course, you remember, this is the net, which is in seconds. You can, oh my gosh, steal or download property quicker than ever than we had to do it with the copy machine or even the fax. What will become of the novelist in the digital age? What are your ethical arguments for and against DVD files copying? At issue in the 21st century is the trade-off between the necessity of writers, musicians and artists, and movie studios to profit from their work, and the free flow of ideas for the public benefit. Very, very important. There's a balance here. That fine line, and who can draw the fine line? Why wait until we go to court? But that's what's going on. Movies and music industry participants claim that encryption programs are necessary to prevent piracy. This is something that you want to protect your business interest. You're right. Others, however, including the defendants in the case discussed in this lecture, argue that they should at least allow purchaser of movie, music, and books in digital form to make limited copies for fair use. If you buy a book, you can read it, you can throw it away, you can give it to someone else or sell it to use as a bookstore. Once you have bought that book, you can legally do just about anything with the except make copies for resale. There is no way that the owner of an intellectual property contained in the book can insert an encryption system to prevent you from letting someone else read it. Very good illustration. Which side of this debate do you support? Is it possible to strike an appropriate balance between the rights of both groups on this issue? Thank you.